Manley, thanks for doing this. This is the first time you've done it, although we've talked about it over the years, but I appreciate you taking the time to be here.
I'm happy to do that.
Why don't you take just a minute and give the students kind of a little overview of your career in the law, and then I'm going to have some specific questions for you.
All right, this is a good-looking group of aspiring young lawyers, and welcome to the profession. Yeah, you hear, I would say preliminarily, at this time you hear a little bit of criticism about lawyers, and but I want to tell you that it is a noble profession. This is my 50th year practicing law, and it is a wonderful profession. It has its problems like all callings do, but if you've chosen a noble profession that is of great benefit to the public and in which you'll have a satisfying life if you follow some of the rules that Pat is trying to teach you and some of the things that our law school wants to teach you. I might tell you just a little bit about how I came to Macon, Georgia. I'm from North Carolina. I was born at a place called Canada Township, which is very, very remote. It was 1941 BE, which means before electricity. Roosevelt and the TVA did not make it to the Canada Township, which was way back in the mountains until in the 50s. So I was born into a culture where people lived without electricity, indoor plumbing, and basically survived on what would be classified as a typical Scotch-Irish farm. You had cattle and raised your own food and the like. It was a very good life, and you just did not have a lot of conveniences. My grandfather, Manley, who I was named for, was illiterate. He couldn't read and write. He was a great man. He couldn't read and write. My salvation was that my mother came there as to teach the 1st through the 6th grade, and she had 3 college degrees. So I grew up in sort of a schizophrenic cultural situation, and moved when I was in grammar school. We moved over to Cullowhee, North Carolina, where Western Carolina University is. The Catamounts, it's a great school. We never won a football game, but it is a great institution. And I actually went to school on the campus. Our school was located on the campus and gave you some substantial advantages. So my interest in education came from my mother, and just in the happenstance that I wound up actually living in Cullowhee and going to school on the college campus and using the college facilities. After finishing high school, I went to Western Carolina 3 years and came to Macon to go to law school at Mercer University in 1960. And 2 of the years I was here, Mercer gave me a full tuition scholarship, which enabled me to go to finish law school, and without that, I would not have been able to do that. So I've always been grateful to Mercer and wanted to do what I could for Mercer and for the Mercer students. When I finished law school, I was a relatively good law student, a good enough law student, so that Judge Boodle gave me a job as his law clerk, which was a wonderful entry-level opportunity for me to have at that time. I clerked for Judge Boodle about 18 months, then took a job in the United States Attorney's Office, working really for the Department of Justice, and I spent about 3.5 years in that office during a time of great interest to a young law student. One of the first things I worked on was a series of cases that we tried in Athens, Georgia, where there was still a lot of activity by the Klan, and there was if you look up Lemuel Penn, he was murdered as part of that situation. At the same time that the incident in Mississippi, which was the basis for the movie Mississippi Burning, took place. In those cases, our case in Athens and the case in Mississippi went to the Supreme Court of the United States at the same time, and they sent back an opinion of clarifying the law having to do with interstate travel and whether interstate travel was a protected constitutional right, and that you had a right to travel in interstate commerce without being molested or certainly without being killed. And we spent one summer trying those cases in Athens. It was heady stuff for someone just out of law school. It was a great opportunity, and it was interesting, and I can't tell you how much I learned from having that opportunity. But I worked on all kind of cases with Judge Boodle, every kind of civil case, every kind of criminal case you could imagine. And then after I left the United States Attorney's Office, I went to work with Hank O'Neill, who was a great trial lawyer. There's a plaque hanging in the hall that talks about him. He was one of Georgia's greatest trial lawyers, and he taught at this law school. He taught criminal procedure. I think he was the last person to actually teach law students how to plead in a criminal case. Now criminal procedure basically is a glorified constitutional law course. Back then it was a course in criminal procedure, because for those of you who are going to practice in Georgia, the demurrer practice is still in vogue. It's still, you still have to understand demurrers. And O'Neill taught a generation of lawyers how to plead and handle general and special demurrers and pleas and abatements and the type of things that you have to know to be an effective criminal lawyer. At any rate, I went to that law firm, and I'm basically still there. It's still O'Neill Brown. I'm the last, the survivor. Everybody else has either left or passed away or through the passage of time. I'm basically still involved in the same legal entity that I began my practice in. I probably spent a good bit of the first 10 years of my practice heavily involved in the trial of criminal cases. I tried every kind of criminal case you could think of. Probably involved in 10 or 15 homicide cases, probably tried about 10 of those type cases, and every other kind of criminal case you could think of. I gradually began doing more personal injury type work. I never did much automobile practice. I did some involving catastrophic type things, but primarily what I did were products liability, medical malpractice, cases that involved expert witnesses and reconstruction. I was probably involved in 6 or 7 cases involving explosions. The last case of that nature that I was involved in was recently with the Savannah. Those of you who probably know about the Savannah sugar mill explosions that happened within the last 5 years. I was involved in three of those cases. But that's basically the kind of practice that I have had over the years. Judge Boodle recommended me to the law school to teach the first trial advocacy course that was taught at this law school. When I was in law school, there was no such thing as trial advocacy. You took one course called moot court. It lasted, an hour's credit. It lasted 3 quarters. Basically, you observed and you were given a factual situation, and you put together and tried one case, and that was your clinical education. And when Dean Beatty came to the law school, he was interested in beginning a trial advocacy program, and Judge Boodle, one of my mentors, recommended me to teach that course, and it was a great opportunity because they allowed me to actually put the course together. So I devised my course the way I thought it ought to be taught. And it basically consists of teaching, giving the students a problem and teaching them how to put together a complete trial book, how to organize a complete trial from beginning to end.
One thing I want the students to notice was the use of the present tense there. It consists of.
It does, and how you, it's important, but.
The course is still being taught, is my point.
It's still being taught. This was my 41st year to teach that course. Obviously, I need to be considering bringing it to a close. Every year they say, well, do it one more year, and I usually agree to, so far I've agreed to do it one more year. I have a younger lawyer who helps me teach the course. I did a rough count and with my secretary a few years ago, and I think I have taught about 2,000 law students. Now that's both an advantage and a disadvantage. But I hear from them, my former students, all the time. I see my students at bar functions and that type of thing. And by and large, I have wound up with a lot of good lawyer friends. And I heard from a student last week that I had not really thought about, I taught him 30 years ago, and he saw my name on somebody's Facebook page and sent me an email, and he told me that, he said, my office is full of trial books and deposition exhibits, all the kind of things that you taught me to do in my course some 30 years ago. I remembered him very well because he was the only student I ever had who made a closing argument, and he started out in front of the jury and ended up in the back of the moot courtroom finishing his argument. So I gave him the award for the most dramatic closing argument in the 40 years that I've been teaching that course.
Speaking of awards, just real quickly, the law school gives an award every year for the adjunct of the year. Do you remember the name of that award?
It is. They were kind enough to I don't know who really fostered that.
Answer the question, Mr. Brown.
It was the Manley Brown Adjunct Professor Award, and they gave it to me the first year, although it had my name on it, and my friend Judge Wilcox, being ever the jokester, said, Brown, it looks like you're giving yourself an award. So, be that as it may, that's sort of a recap of my life in the law. That is comprised, as I say, now about 50 years.
Go back for just a minute, because these students don't know about Judge Boodle. Every Mercer student should know about Judge Boodle, and you had this very unusual opportunity to work for him, in very close circumstances, and knew him, of course, for many, many years. Can you tell the students a little bit about Judge Boodle and his importance to this institution and to the law in general?
Judge Boodle finished at Mercer, I guess, in probably around 1920. He came here from South Carolina. He loved Mercer University. The judge, he was the youngest. He became the youngest United States attorney in the history of the country. He became United States attorney in the 20s. At one time, while he was practicing law, he was dean of the Mercer Law School. He served for many years on the board of trustees and had a lot to do with preserving the integrity of the university and protecting its mission in life, in terms of devising a way to have trustees that would honor the academic integrity of the university. So Mercer University as a whole obviously owes a great debt to Judge Boodle, and always loved him, and he always loved Mercer University, but he really loved the Mercer Law School. Judge Boodle and I had two things really in common during the time that I spent with him, and we spent almost every working day together and traveling together, and we talked about two things. We were Baptists, and we were Mercer Law School graduates. So we talked a lot about the Baptist and about Mercer. And working with Judge Boodle was like getting a PhD, or probably better than having a PhD from Harvard. He was a born teacher, and he was interested in teaching the clerks who worked for him, if you were interested in listening to it. And I think Pat at one time clerked for a judge. And if you have a judge like that, some judges use their law clerks to get them a Coke, bring them refreshments, and do all kind of things that really don't enrich your education. But Judge Boodle, he told me when I went to work for him, he said, "Now, Manley, I want you to learn everything you can while you work for me. And I want you to come in the courtroom. I want you to keep your work up and keep our motion docket current and do the research and draft the opinions. But when we do something in the courtroom, I want you to feel free to come sit in the courtroom and watch lawyers work in the courtroom, because that will enrich your future if you intend to have a life in the courtroom as a trial lawyer." So, and that's what I did. And he would patiently explain to me anything that I wanted to know about what was happening. So it was wonderful to have Judge Boodle teaching me about the court. Why are lawyers doing this? Is this the right thing to do? If it's the wrong thing, why was it the wrong thing to do? And then of course he recommended me to teach the trial advocacy course at this law school, and I'm still to some extent doing that.
Well, Judge Boodle lived to be 104. He had an amazing life. But of course, he's most famous as the judge who in 1961 ordered the desegregation of the University of Georgia.
Yeah, Judge Boodle, there's an oral history of Judge Boodle, and actually Mercer has it on CD. It would be a real education if you check that out sometime and just sat and watched it and listened to it. His career, he was a great trial lawyer in addition to being a great judge, and he preserved a lot of his papers, the exhibits that he prepared to use in trials and the like. Pat and I were talking on it's really unfortunate that Mercer does not have more of Judge Boodle's papers than they do, because they're interesting and would be a real treasure for the school if we had preserved them properly.
I want to switch to your work and work that you still do representing plaintiffs. I will tell you that Judge Sizemore has visited with the class. By the way, mentioned you and honored you as his mentor, mentioned Hank O'Neill, so those names are familiar to these students. But my question really is very simple. What do you like about it? You're still doing it. You don't really have to do it anymore, do you? I mean,
well,
what do you like about it?
Representing plaintiffs, the most difficult thing about practicing law is you have clients. And it would be a wonderful profession if you didn't have clients.
My boss used to say, if you could do it without clients, judges, or other lawyers.
In my lifetime, probably the way my practice developed, about probably 75% of what I did over the years was for lawyers. Basically had lawyers that I helped with various projects. That's one reason I tried to learn how to do the more difficult cases where you use engineers and medical people and a lot of expert witnesses, is that I had more time to concentrate on preparing cases and trying them, and without spending an inordinate amount of time with the clients, although you always have to spend a lot of time with the people that you represent to be sure that they're properly taken care of and that they understand exactly what's taking place. I guess the most satisfying thing about practicing law generally is you have the ability to use the law to accomplish something. A law degree is a source of real power, And you need to understand that when you're given the right to practice law and to use court processes and to bring the weight of government to bear on issues, resolving issues, that's a tremendous power. And with that power is a tremendous obligation and responsibility. And part of that has to do with what Pat is teaching you in this course. That's professionalism and ethics. In other words, how do you use that power? Because you have the power in Macon, Georgia, to make somebody in Poughkeepsie, New York, respond to a legal proceeding in Warner Robins, Georgia, and to make them do certain things. So you have a lot of power. It's a power not to be abused, but it's a power, if you understand the rules of law that apply to it, that you can bring to bear to accomplish things for people who have serious issues that need to be resolved. So I think and it's satisfying to be able to do that, to have the knowledge and training and ability to look at this problem and by using your training and your education and the courts, be able to solve this difficult problem for somebody, or make somebody respond. So for a plaintiff, if something happens in Warner Robins, Georgia, that inflicts a serious injury on an individual, and you're able to make maybe in a group somebody who's responsible for it, or some corporation or individual in California respond to that in the location where you live and correct that situation. That's real power when you think about it. And so, as I say, there's a certain responsibility that comes with that, with the exercise of that power, and certain rules of ethics that you need to be cognizant of.
You know, the students learn in this course a particular definition or structure of the study of professionalism. But I want to ask you whether, in your many years in practice, what have you encountered that you would call issues of professionalism, and how did you deal with it?
Well, basically, professionalism is really basically manners, and it's professional manners. There weren't as many lawyers practicing law when I came to the bar as there are now. And as the number of lawyers grew, the professionalism standards seem to have retreated somewhat. And I think part of that's attributable to the fact that when I started practicing law, you dealt with the same lawyers over and over on a very frequent basis. So there was really self-preservation dictated that you treat people professionally and use good manners. Now, a lot of the lawyers you encounter you never see again. And everybody involved in litigation realizes, I'll never see these people again. And there's a tendency then, perhaps not to be quite as professional as otherwise. But it's basically a question of manners, and to be able to do that, you have to sort of develop a survival technique to get along in that situation. And the one that I personally subscribe to is to just push ahead, to avoid getting into an argument with somebody. I mean, the opportunity for that is ever present. And my way of dealing with that was simply just not to stop and get into an argument with an opposing counsel over an issue that there's no judge present. You can't resolve it. And if you have to get in the last word, it usually devolves into some unpleasant situation. And my way of handling that is if I'm taking a deposition and somebody is out of order or keeps creating a problem, I just basically push on. Go ahead and do what in other words, a lot of times I think that is used, lawyers use that maybe as a technique, they think, to distract what you're doing or get you off the track. And I've found that the best way to handle that is not to stop and have an argument with somebody, but is just push on. If you're well prepared, just go ahead and let them say whatever they want to say, and proceed. If you get into an argument, then that, to me, it ramps up the whole situation, and everybody feels that they have to get in the last word, and you don't really accomplish anything. And so my view is just continue what you came there to do. You want to ask some questions, get some answers, and to follow that format.
Is there one occasion that sticks out in your mind of what you would use as an example of unprofessional conduct from another lawyer?
Well,
you don't have to name names.
It's basically the biggest problem in the discovery process amongst lawyers is coaching the witness at depositions. In other words, through an objection, and it's the thing that seems to give lawyers the biggest problem. In other words, you ask a really good question, and the witness realizes, this is a good question, and I'm going to have a hard time answering this. The lawyer on the other side thinking, this is a tough question, and it's going to hurt. So they make an objection, and it's kind of a speaking objection. They object and incorporate in that objection the answer they want the witness to give, which is perfectly unethical and improper. But it happens all the time, and it causes more trouble than anything else. So you really have to deal with that. And if it's too bad, you really just have to stop the deposition. Most judges, particularly in the federal system, want you just to call them on the telephone. You just call them, and everybody gets on the telephone, and you settle it right there. Because you can't take a deposition if a lawyer on the other side persists in actually testifying for the witness, telling the witness what to say. That's the most common problem that you're going to encounter. The remedy for that is to prepare the witness properly, so you don't have to feel the need to do that type of thing. Is to spend the time that you need to spend with your witness, prepare them properly, and if you have to object to something, then object. But you're not supposed to object and give the testimony for the witness. That's the most common problem that I have seen over the years in depositions.
Mm-hmm. Well, of course, that was going on 25 years ago when I was in private practice.
Yes,
I'm
it's
disappointed
been going
to
on
hear
a long time.
it's still going on. I don't want to give the students the wrong impression, because we talk about, we describe that kind of thing as incivility. But you deal with defense lawyers all the time, and often you'll have the same lawyers you've seen before. What's your relationship like generally with the defense bar?
Well, my life in law, I've always been able to get along with almost all of the defense lawyers I have dealt with. I try to keep things on a real high plane, and part of it, in the beginning, we all knew each other very well. Some of them you've gone to law school with, or you knew through bar activities and the like. Nowadays, there's an opportunity, in most situations, you probably will not know opposing counsel very well, particularly if you're a young lawyer. You just haven't had time to learn exactly what the names and the backgrounds of the people you're dealing with. But my basic relationship with defense, I treated defense lawyers respectfully. There are people in the plaintiff's practice that feel that you should not necessarily do that. I mean, their approach to their opponents has a little harsh edge to it.
Us versus them.
Yes, us versus them. It's Armageddon, and it's a fight to the death. My intuition told me in my basic upbringing not to do that, and I never did. And I had the defense lawyers that I dealt with, by and large, I got along with them very well. At times they would, in some case that I wasn't involved with, they would call me on the telephone to help them with some issue. I had a number of defense lawyers that they would call me regularly, and I would give them the benefit of my thinking about experts they needed in other cases that I was not involved with. At times I represented some of their clients. I defended a lot of medical negligence cases that people were disqualified in, and or there was some insurance problem. So I traded cases with members of the defense bar. But Lamar Sizemore, and I practiced 25 years, and we got along very well with the defense bar. I found that was beneficial, probably in the long run, to our clients, and certainly did not hurt anybody. You have to be able to agree with the lawyers you litigate against on certain issues. Otherwise, you're fighting over every little bitty transaction. You waste a lot of time, and you can accomplish a lot of cases if you have a certain respect for your opponent and he has a certain respect for you, so that you can actually discuss something and resolve an issue. You can't try all the cases you have in your lifetime. You've got to resolve a lot of those. So you have to carefully guard your integrity, so that if you practice law in a way so that everybody hates you, you'll never really be able to, or mistrust you, you'll never be able to resolve anything. There's nothing unethical about being friendly to your opponent. You don't give your case away, but there's nothing wrong with good manners and trying to be a lady or a gentleman in your practice.
I want to ask you something I haven't asked anybody who's come in here yet, and that is, have you encountered a judge that you thought was in any sense unprofessional or biased, and if so, what was it and how did you deal with it?
Yeah, all the time you're gonna encounter that. It happens. I mean, you have great judges, and you have to remember a judge is a human being. So there is a tendency, if you're a judge, to look at the case before you and perhaps lean a little bit one way or the other. You think one side or the other is maybe has a little more merit to it, or there's something about it that rubs you the wrong way. I mean, that just happens. Now, you're not going to be able to avoid that, and sometimes you're just getting just like a basketball game or a football. You get a little home cooking. I mean, you depending on where you are. That's just reality. So you have to be able to accept that. That don't mean that that's necessarily unethical. Although the judge is supposed to be totally impartial, but that's in many cases that's not necessarily true. Now, how do you deal with that? That's where this law school comes into play. All of you, this is your first year in law school, so you have basically most of your legal education ahead of you. How do you deal with that? The judge, occasionally you'll have a judge that it seems probably doesn't like you. I mean, for some reason you don't. I wear Western boots. I like to wear boots. I've worn them my entire adult life. I wore them into my children's weddings and over the objection of various. It's just part of my persona. I had at least one occasion where the judge didn't like the fact that I wore these boots, and really gave me a very hard. I felt for no good reason that I had a very hard time from the open. It was a very difficult case from the opening gong. I think it had something to do with that. I didn't know what else to ascribe it to. How do you protect yourself from that? All right, you have to learn. If you want to protect yourself, you have to be able to diffuse that, and you have to be able to make a good record. You have to understand evidence. You have to know the law of evidence code. You have to know the law of procedure code. You have to understand the rules of law that apply in a courtroom cold. You don't have time to look all this stuff up. You have to, when you walk into that courtroom, you have to be very well prepared on the rules of law. That's what protects you. Because the law is the law, regardless of what the judge thinks about. In the situation that I'm telling you about, I lost that case, but it was reversed on six different issues that we had preserved in the record, and the court just stopped at that point and said, well, the other things we hope won't happen the next time this case is tried. Well, if you're in a courtroom and you don't understand evidence, and you don't understand procedure, and you don't understand the rules of law that apply in the courtroom setting, you're going to be had. I mean, you can be easily abused by, not just by opposing counsel, but if a judge for some reason doesn't like you or doesn't like your case, they will really do a number on you. Now, if you understand the rules of law, it will be obvious fairly soon to the court and to your opponents that you do understand the rules of law and that you are determined to be sure that they're complied with, and you know the objections to make and how to preserve those objections and how to raise the issues that need to be raised to make the trial proceed according to the rules of law. I say that to you because you still have, if you were a last year senior, it would be too late. If you've been wasting your time, if you had your laptop open in class, checking your fantasy football while somebody was trying to teach you evidence, it's too late. You screwed up. I mean, you don't know what you need to know. This group, you're just getting started, so you have all of that. You have 2 years ahead of you to be sure that while you're at the Mercer University Law School, you learn everything you can. Learn every rule. I'm here to tell you, you're gonna need it to be able to have a successful life in the law, to protect you. If you want to be trial lawyers, if some of you may want to do something else for a living, but if you want to go into a courtroom, one of my mentors told me, said, Brown, listen, a courtroom and an operating room are two dangerous places. You really have to be on your toes and proceed with the utmost care. But your ability to survive and do well depends on what you know. It's trial lawyering is a little bit like boxing. You get in a ring to box, it's you and the other person, and only one person speaks at a time in a courtroom, and a lot of times it's you and them. I mean, it's a very personal thing. It rests on your shoulder, and what you know is very important. And if you don't know it, then you'll be taken advantage of and never realize what happened to you. And you won't really know how to effectively protect yourself from what Pat is suggesting, that if you have a judge who won't listen to you, or for some reason is determined to head your case in a direction you don't want it to go, you have to be able to protect yourself. And knowledge is power, as I say, and knowledge in the courtroom is everything. Knowledge and experience. You can't wait until you get it through experience. Basically, you have to get it while you're here. That's the foundation of the rest of your life in this law practice is going to be set right here in this group of buildings over the next couple of years. It will determine what your lifetime is going to be like. When I went to Mercer Law School, we had 120 students, and it was all business. I mean, there was no You were expected to learn. I mean, we took everything. We took foundational courses. You need to take conflicts of law, take all the evidence courses you can, take federal practice. Don't take some cushy, sexy sounding course that's not going to help you be a lawyer. If you want to be a trial lawyer, you got to know those. You got to know those basic things, or you can't function. You have to take a course if you're going to practice in Georgia, and practice in procedure, so that you understand those things. And it's just like learning anatomy. If you want to be a doctor, you got to know that, and you got to know it cold, and you got to have it in your head. The federal rules of evidence. You got to know the federal rules of evidence. You want to pass the bar, learn the federal rules of evidence cold, and that'll probably be the key. And you can do that. So that's how to protect yourself from that sort of thing.
And my question was about judges, but that applies to other lawyers trying to take advantage of you as well. Your boxing analogy is in play there, that it's knowledge and experience that protect you, but you start without experience, right?
You
so
do
the
it.
knowledge is what
So
you
you
need.
got to get the knowledge. The only thing, you can't get the experience while you're here. But you can get the knowledge. You just use your time. Just study. Don't waste your time. It's expensive to go to law school. Not just your time, and expensive in time and money. So when you leave here, you want to get what you paid for, and what you paid for was knowledge. That helps you pass the bar, and it'll help you do a good job. The law practice has always been difficult at the entry level. I think there's a feeling that it's a lot harder nowadays than it once was, but I don't know that it is. It's always been difficult. You got to get a job, then you got to prove to somebody that look, I am a good lawyer. I am going to be a good lawyer. And whoever you go to work for, if they ask you to do something, you want to know how to do that, if at all possible. Don't come back and ask them, well, how do I do what you want me to do? They're not interested in being a fourth year of law school. They want you to know evidence and procedure and how to organize. That's why I teach my students how to do a trial book. And I can't tell you how many students have told me, well, that really helped me. I was able to do that for some older lawyer that I went to work for. I was able to sit down and organize his or her trial into this notebook and give it back to him. And that helped me tremendously to progress in that professional situation. Lawyers, I had lunch with a lawyer in Atlanta a year or so ago, and one thing he said about the Mercer students, he said, we lack the Mercer students because they're practice ready. They're practice ready. That's what they want. They need you not to just discuss with them the law. They want you to help them make money and represent their clients, handle these cases. They want you to be practice ready, not asking them to then teach you how to practice law. You'll learn a lot from them, but if you have something to give to these lawyers that you go to work for, it will help you progress in your professional life. You'll be amazed what that will do for you. And as I say, the people I talk to lawyers all over the state all the time, and by and large they like the Mercer students because of this practice ready idea, that you're ready to practice law. So what you want to do is strive while you're here to be practice ready when you leave, and that includes professionalism, professional conduct, following the rules of ethics. Because if you make mistakes about ethics and everything, you ruin your career. If you get a reputation of being a sharp practitioner, I had it was an older judge who taught us all our procedure and the evidence courses, and he told us now listen, guys said, don't do something to get a short term. Don't do something improper to get a short term advantage. He said, if you do it, you'll ruin your life as a lawyer because nobody will trust you, and that will impair your ability to practice law. Follow the rules. You'll have a lot of opportunities sort of, maybe to do something or misrepresent something or take advantage of something that will help you at that time, a short-term advantage, but if you get a reputation for that, it will ruin your life as a lawyer. And at the end of the day, I can tell you, because I'm 73 years old, I know, you know, I'm in overtime. According to the 91st Psalm, I'm 3 years in overtime. So I know I'm going to fall off the mortality table at some point in the future. You can't even conceive of that. But you have your life ahead of you. It's a long time to practice, and it is really important to you at the end of the day how other people view you at the end of your career. That people view you as, if somebody asks you, how about Lawyer Brown? Well, he's an honest man. Somebody says, you're an honest person. You really say, well, I don't know, maybe you don't feel that way now, but I tell you, at the end of your career, you will want to feel that at least the other, maybe you didn't become a multi-millionaire, you weren't Clarence Darrow reincarnated, but you were a good lawyer, and you practiced your profession in a way that that you have respect. That people respect you as a human being and as a lawyer. That will be important to you at the end of the day.
To look back at it towards the end and say that was a life well lived.
And Judge Boodle had a talk. He used to come and talk to the students at the beginning, at the law school every year, to the incoming class, and I've heard him make that talk, and he talked about how you build a reputation. So you build a reputation one thing at a time, one case at a time, one act at a time, and so your reputation is this. It's your body of work over this long period of time that says who you are. But one mistake, one serious ethical mistake, as Judge Atkinson used to tell us, for a short-term advantage, can destroy that all that you've worked for all those years. You'll see that happen. I've had students that things like that happen to, and it's a sad, hurtful feeling to see that come to pass. And you have to guard against it. It helps if you have an older lawyer when you get out into practice. If you find an older lawyer who's willing to mentor you a little bit, or who likes you, or whom you really trust, that you can, if you're about to do something and you feel a little uneasy about it, call them up and ask them. Say, I can't tell you how many people have called me and say, this is what I'm thinking about doing. You say, no, don't do that, and this is why. I can tell you why you don't need to do that, because what you don't see are the consequences a little further on down the road. So it's helpful and you'll find that there are plenty of lawyers at the bar who are willing to help young lawyers. Some don't, some won't give you the time of day. But they're there. Other Mercer lawyers, I found down through the years, I can't tell you how much benefit I got from older Mercer lawyers that I encountered down through the years that helped me and did things for me and opened doors for me and took time. We were a smaller group of lawyers, and it was more a collegial atmosphere that remained amongst us. I think a lot of that still prevails. Look around for the Mercer people, and if you find somebody that you trust and you admire, and don't call them up 5 times a week to practice law for you, but if you have a serious problem, call them on the telephone and let them give you a little practical advice. It may save you, may help you with something, and may help you prevent you from making a mistake.
I'm going to turn it over to the students for a few minutes, see if they have questions for you. I've got my list, but I want to say, yes, sir.
What's in your trial book?
All right, what's in the trial book? Now, this is the short version.
All right, it's a trial.
Not the semester version.
It's a trial. It starts with a list of witnesses, your exhibit list. They aren't necessarily made in that order, but your exhibit list, your list of witnesses, your opening statement, your case on direct, depending on whether you're a plaintiff or a defendant, your cross-examination. You write out all your questions. You have a legal memorandum relative to the substantive law that applies to the case. Request to charge. You have the section on your request to charge that you're going to hand up at the for the judge to use in connection with the charge, and a closing argument. So I give what you would have would be a problem, and the problem requires you to be, you get a client to represent in that problem, and you prepare that trial book as if you're going to conduct a trial on the merits for that particular client. And I have a lot of students that tell me, I've still got my trial book. I was up in Rome in a boiler explosion case up there, and was in a law firm, and one of my former students said, he opened his desk drawer and said, "There's my trial book. I've still got it from 20 years ago, and I've always referred to it. I've always used it." And this time I asked a question on my exam. This time that I never asked, just to see how it would come out as sort of an evaluation tool. I asked the students to tell me what you learned in this course. What's the primary thing you learned sitting in this course? And I had one student say something to the effect, I want to thank you. This is the first time in my life I've ever had to do a major project on time or face the consequences. I thought I was astounded. He said, this is the first time. But by and large, the answers were, well, this makes me understand what I've been trying to learn, what I've learned, how I would bring that to bear. It's helped me learn what I need to do in order to actually get myself in the courtroom and try a case. It's forced me to review every little bit of my case so that I understand it when I'm.
Well, we'll beg Manley to stay on 2 more years, and you can find out. Other questions for Manley? We've got time for probably just one more.
Oh, sure. I'll ask.
Okay.
Yes. So I realized law school's changed a lot from when the Psalms were written when you were around. But no, I'm kidding. But you said. All right. Anyway, you said that you have some recommendations of things that we should learn, and we should courses that we should take. Are there any I guess regrets from your law school career? Things that you wish you had done? A competition, someone you might have asked at the barrister's ball, some opportunity that you think is really essential for us, like some of these classes that you're talking about.
You've got about a minute. Maybe.
It was easier for us because we didn't have a lot of electives. We were basically told, this is what you need to be studying. We did have a couple of electives. One was like legal philosophy. It was a trap. The people who took it wish they hadn't. It turned out to be a very difficult, not very useful, and very difficult. So I really can't. I got a very basic, a really good. I found that I had as good an education as anybody that I encountered. A good when I finished law school and started practicing, and it was. I really didn't select the courses that I took. I took what was there. That we were told these are the courses you need to take, and basically that's the way that worked.
Man, I'd love to continue this, but we're out of time. So please join me in thanking Manley.